litigation as a means to meet the goals and objectives of our client.
I wanted to take a little bit of time to discuss the presidential election, the electoral college process under the Constitution, and what is everybody so excited about January 6th for. So, before we get started, there's been a lot of discussion that the House of Representatives would have the authority to throw out electors from various contested states based on the allegations of widespread voter misconduct and fraudulent activities. We saw recently, as this New York Times article states, in the 2004 general election, there was a challenge to the electors of Ohio whose votes for the Electoral College were sent to the joint session of Congress on January 6th. Then there was a sponsor, Barbara Boxer, and Stephanie Tubbs of Ohio to challenge the 20 electoral votes. Where did this power come from, and what does it mean? And what are the potential outcomes for 2021's January 6th session in Congress to receive and count the Electoral College votes? Under the United States Code, Section 15, counting electoral votes in Congress, it says here that Congress shall be in session on the 6th day of January, after the electors meet, and upon such reading of any such certificate of paper, the President of the Senate shall call for objections. So understand here that per the process, I guess there are these two individuals who have a ministerial role of collecting the electoral ballots of the Electoral College and presenting them to the Vice President, who is the President of the Senate under the Constitution. And then they go through the roll and they actually count the votes. And if there is an objection, then the objection shall be made in writing and shall state clearly and concisely and without argument the ground thereof, and shall be signed by at least one senator and one member of the House before the objection is received. After an objection is received, the Senate shall withdraw to its House, and the objections will be submitted there. And likewise, the House of Representatives, the Speaker will present the objections before that body for deliberation. After the objection, so what are the basis of the objections for the electors? And here we have what I believe is the pertinent language here. Of course, there's ministerial objections, and the statutes set this forth. Maybe the certified votes from the state were not handled or delivered properly to the particular federal clerk's office that's supposed to receive them. Maybe there's markings or they're ruined, and there's some procedural defect or basis. But what we're focused on here, and I think where the president and the GOP are headed for, is a substantive argument for the acceptance, or for the objection rather, of the electors. And here we have the two houses concurrently may reject the vote or votes when they agree that such vote or votes have not been so regularly given by the electors whose appointments have been so certified. Now we know in many of these contested battleground states, and as general procedure throughout the country, the Secretary of State of the state will certify the election, and then then the electors will go to the state house and mark their electoral college vote, and those will be the certified votes. Now, when we talk about legal issues where the votes have not been so regularly given by the electors, I think we're opening up the door in this language for all sorts of constitutional arguments about due process, equal protection of the election proceedings in the individual states. And this is where things get really thorny, and I think that this is where you get the political football and you see court decisions sort of tending away from making what are deemed to be political decisions. And we're going to talk about Justice Ginsburg's dissent in a little while, where she lays out this very important distinction. She was a dissent. This is in the Bush versus Gore case, where the majority of the Supreme Court interjected itself to determine that substantive or procedural due process and equal protection was violated by the Florida Supreme Court in its mandate handed down to its state election counting officials. But again, this is really thorny, and that's why we're seeing so much complexity and so much hand-wringing and uncertainty, frankly, about where this thing is going to end up. But in any event, we understand that a positive vote by the House and the Senate to reject certain electoral votes because they were not regularly given will nullify and kick out those votes and potentially send it down to the House of Representatives for the ultimate vote and deliberation. We also have these conditional electors ballots that have been sent in the event that the first slate of electors are kicked out by the House and the Senate. So U.S. Code Section 5, determination of controversy as to appointment of electors, I think is an important issue and important statute. I'm not sure, I haven't found really any definitive cases about this, but it does seem that it's tangentially discussed. But the import of this particular statute basically says that, and this creates with this quote-unquote safe harbor provision. So it says that basically if the states provided by their laws enacted prior to the appointment of the electors of the election makes a final determination of any controversy or contest concerning the appointment of all or any of these electors by such a state by judicial or other methods or procedures, then the Congress is supposed to more or less play a ministerial role and rubber stamp those electoral votes. That's the way I read this statute. Again, so to reiterate that and say it perhaps a little bit clearer, if the state certifies and appoints its electors by final determination or controversy or a contest by the judicial or other method or proceedings within 6 days before the electors are supposed to meet, then the Congress, upon the receipt of those electors, is supposed to serve a rubber stamp function. Now, this gets really thorny again. Why? Because we know that the federal courts, at least since Bush v. Gore and as early as some other holdings, find that procedural or due process and equal protection clause of the U.S. Constitution can be used by the federal courts to invalidate or cancel elections and have an impact on the elections. So, as we're seeing here play out, the states have largely spoken at this point. You have certification of electors within this safe harbor period. Those electors have been certified. Any quote-unquote controversy may have been reached or otherwise mooted or addressed prior to 6 days before the meeting of their electors. So the question begs, what if there's outstanding lawsuits or new lawsuits that are filed after this 6-day safe harbor provision? What if cases are still being heard? What if a legislature of a particular state, after the certification of a slate of electors, makes a motion or somehow procedurally seeks to overturn the certification prior filed by its state? really thick, thorny, hard things to think about, and in the manner in which these would actually play out. But I'm just putting this particular provision out there because this sort of governs where the members of Congress would or would not maybe perhaps have to rubber stamp electors that are presented to it. But I think if we flash back to 3 Code Section 15 about counting, we're still getting into this theory of we're rubbing up and we're conflicting with substantive, procedural, due process, and equal protection violations. So if a state knowingly acts illegally or in contravention of due process rights and violates equal protection in the election that it's certified, if it's a final statement of the state, should it not be counted under the safe harbor provision? Or would the Congress have the authority still to challenge and throw out those ballots in the face of its perhaps ministerial duty of just counting the electoral ballots? And I think what you found here in this New York Times article, I just happen to have found this one first. It's the move that was made in 2000 turned what would otherwise have been a polite ceremony into a political historical drama. And drama is something that undermines the legitimacy of the presidential election system and is not necessarily healthy for the democracy, but sometimes I guess you got to break a few eggs if you're going to achieve justice and better the situation in the future. We're going to get onto some of those issues a bit later in this, but we certainly see and start to get the complexity of where we are here. And I want to bring you to this is the Bush v. Gore decision of 2000. And basically, in this case, the Supreme Court had to decide whether the Florida Supreme Court established new standards for resolving presidential election contests, thereby violating Article 2, Section 1, Clause 2 of the United States Constitution, and failing to comply with 3 U.S.C. 5, and whether the use of standardless manual recounts violates the Equal Protection and Due Process Clauses. With respect to the Equal Protection Clause, we find a violation. Now, the issue here was that the Supreme Court of the state of Florida had handed down a decision saying that the recount of these hanging chad ballots must be remanded to the vote counters so that those vote counters can ascertain and determine the intent of the voter. The problem is that absent a specific standard to ensure equal application of how do you figure out the intent of the voter across a large state, you couldn't get a uniform rule to determine this you couldn't get an objective, uniformly applied rule to the entire state that would comply with the due process requirements and equal protection. In other words, you couldn't apply a standard of voter intent for staring at ballots that are going to be promulgated by one jurisdiction in Florida, and then in a county, 100 miles away, you couldn't then have a separate set of standards or rules applied to determine standards and methods to what was the intent of a voter there. That violates equal protection. And that's basically what the court found in its decision in remanding it down. But importantly here, the proclamation of the law that the right to vote is protected in more than the initial allocation of the franchise. Equal protection applies as well as to the manner of its exercise. Having once granted the right to vote on equal terms, the state may not, by later arbitrary and disparate treatment, value one person's vote over that of another. It should be remembered that the right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote, just as effectively as by wholly prohibiting the free exercise of the franchise. Very important statement. This statement of the law is, I believe, the black letter of the law, and this is the law. So if it's dealing with fraud or theft or foreign interference or whatever other arguments are going to be raised by the members of the House and by members of the Senate on January 6th, I keep forgetting the date, January 6th, this general rule is the law of the land. And if you are debasing or diluting votes by casting tens of thousands of illegal votes, that is a clear violation of equal protection. And I believe there is a basis for the two houses to say that these votes have not been regularly given by the electors due to the underlying problems in the elections, those being equal protection and due process violations. Now, let's see, this is 23, 26. Okay, so Justice Ginsburg dissented in the Bush v. Gore decision. And I think what the principles and what Justice Ginsburg relies upon in her decision and her general philosophy about her understanding of the Constitution and the role of the courts as it pertains to presidential elections is that the courts should necessarily be the last line of defense. The Constitution of the states clearly set forth and should regulations and laws about how their presidential elections are handled and how their electors are selected, as well as laws and regulations to ensure equal protection and due process of all enfranchised voters are protected. Against that backdrop, Justice Ginsburg pointed to the Constitution, the United States Constitution, as well as the statutes to say the legislature or the law as written in statutes by the legislative branches and ordered into law or signed into law by the executive branch set forth, and in the case of constitutional amendments, gone to the states for their ratification, blah, blah. But what she says is that there's a very clear roadmap, and the rules of the road with respect to counting electoral college votes on January 6th are clearly set forth. And in the clear language of those statutes and our Constitution, puts this ball squarely in the court of the legislative, political branches of the government and not in the body of the courts. So she talks about issues of federalism, which we give the states these rights to select electors. And she says that neither side, now this is an interesting distinguishing factor because in this case, in Bush v. Gore, nobody claimed electoral fraud, dishonesty, or the like. And the mere fundamental equal protection claims might have been left to the state court to resolve if and when it was discovered to have mattered. Pardon me. Neither side in this landmark case of the U.S. Supreme Court was based upon facts of claims of electoral fraud, dishonesty, or the like. What you are going to see on January 6th are arguments by members of Congress that specifically deal with claims of electoral fraud, dishonesty, and the like, as well as, I believe, claims of foreign interference in our federal elections. That, unto itself, is an extraordinary distinguishing factor that will distinguish cases and this election from the Supreme Court's holding in Bush v. Gore. One interesting note, and I don't know if I'm going to be able to find it here, but there's reference. Let's see. I think the word is extraordinary. Yes. Okay. So let's find that word. I believe this is maybe still in the justice's dissent, but she says, yeah. So this, it's interesting. This must be the dissent because it's really, so the Chief Justice's casual citation of cases might lead one to believe they're part of a larger collection of cases which said that the Constitution impelled the Supreme Court to put a skeptical eye on the state court's portrayal of state law. Sorry. Okay. I just want to see who says this. This still may be the dissent. So I'm here at page 18, and we have Ginsburg dissent at 20. So this is actually part of this may be just part of the decision. Let's go back here. Okay. The extraordinary setting of this case has obscured the ordinary principle that dictates its proper resolution. Federal courts defer to state high courts' interpretations of the state's own law. This principle reflects the core of federalism on which we all agree. The framers split the atom of sovereignty. It was the genius of their idea that our citizens would have two political capacities, one state and one in federal, each protected from the incursion by the other. The extraordinary setting of this case has obscured the ordinary principle that dictates its proper resolution, which means that federal courts should defer to state high courts' resolution of interpretations of the state's own law. Now, that doesn't necessarily mean that in the Trump election that the federal government would necessarily, or the federal courts would necessarily have to defer to the state's highest courts with respect to federal constitutionally protected rights. But it certainly means, at least in the Bush v. Gore setting, as well as what we're going to find will play out on January 6th, where the state's highest court makes a determination as to the validity of the activities and actions surrounding their election, has spoken, the general rule is that the federal courts will not interfere with that state court's determination. Which brings us back to the ultimate constitutional question here, which is the state legislators have the power under Article 2 to create and set the laws for the election of the electors. And you're going to see numerous arguments, in which arguments have already been made by the Trump legal team, that they didn't. You had state law, and then you had the executive branch of the state governments changing the regulations that were not approved, promulgated, passed, or otherwise done by the legislature, which impacted the election. Those cases have been tossed on standing grounds and other grounds, but that's the thrust of those arguments about how the states, ran afoul of Article 2 of the Constitution. And what we have here is the backdrop of the general premise that federal courts are not going to get involved. We put this to the states for their own people to figure it out. And that's, again, where we get into this, Section 5. If the state did what it was supposed to do, giving them wide latitude in this federalist system to figure their own stuff out, then what business do we have as the federal government or as the members of Congress in accepting the electoral votes to say they didn't do good enough? Well, I think Bush v. Gore gives us the roadmap for that. And that word is fraud. Where they are going to, the Supreme Court or whatever court it is, or the electors will be able to, those challenging the electors will say there was fraud and dishonesty. So again, we have a distinguishing thing. But let's get back to the roadmap and why the judge says this is a political issue, not a legal issue. The Constitution and the statutes provide the roadmap. It foresees a resolution of electoral disputes by the states, providing that where the state shall have provided by the laws enacted for its final determination of any controversy or contest concerning the appointment of electors by judicial or other methods. Those subsequently chosen electors enter the safe harbor free from congressional challenge. Again, very important. The federal Constitution broadly says that the elector shall be chosen, pursuant to the legislators of the various states. Now, again, we have that rub here where we have people doing extra legislative actions with respect to voting. But then we also have this broader principle of, well, what is the legislature? Some may argue that the state courts would interpret the actions of what the legislature is. And you can't even have a law under, I believe, most of these state constitutions without a governor or the executive of the state signing the bill into law. And then you get into questions which have been addressed by the state courts already is, well, was this extra legislative activity that was done a due process violation or an equal protection violation, even though it wasn't done by the legislature? But didn't the legislature grant the executive some executive authority to act and undertake certain activities during what they would call a state of emergency or just in the ordinary course of business of executive authority and executive action? Did not the legislature delegate that authority? I don't know. But this is what makes this so complicated. But again, now we have the 12th Amendment. And it says here that Congress has the authority and responsibility to count the votes. The Congress is the body primarily authorized to resolve the disputes. And the legislative history of the acts makes it clear its intent to commit the power to resolve disputes to Congress, not the courts. The two houses are, by the Constitution, authorized to make the count of electoral votes. They can only count legal votes, and in doing so must determine from the best evidence to be had what are legal votes. Now, this is the legislative history of the 12th Amendment, and just reading this again, this basically is the standard by which the House of Representatives and the Congress, and the Senate are going to have to act. They can only count the legal votes, and in doing so, they must determine which votes are legal. The Congress, the legislators, the political body decides. Will the judicial system be charged between January 6th and Inauguration Day to determine whether Congress properly concluded whether only the legal votes were counted? I don't know. But that is the most logical outcome in the face of the political process on January 6th playing out. And here the act of the statutes go further, which is pointed out by Justice Ginsburg, that if a state submits a single slate of electors, Congress must count those votes unless both houses agree those votes have not been regularly given, if there's two slate of electors that are given, and so on and so forth. So we have a very distinct roadmap to be followed. Now, so what are we going to look at? And incidentally, by the way, this is fascinating to me here, because when you're saying that the two houses are authorized to make the count of electoral votes and they can only count legal votes, and in doing so must determine from the best evidence to be had what they are, we're getting into the issue of votes being regularly given. And that's where this constitutionality of counting electoral votes in Congress counts. So here we are, January 6th of 2005. This was candidate Kerry against, I believe it was George Bush. And this is what happens on January 6th. A joint session of the House and Senate for counting electoral votes. At 1 o'clock, they all are at the House. Mr. Vice President, the Vice President, Mr. Speaker and members of Congress, pursuant to the Constitution and laws of the United States, the Senate and House representatives are meeting in joint session to verify the certificates and count the votes of the electors of the several states for President and Vice President of the United States. After ascertainment has been had that the certificates are authentic and correct in form, the tellers will count and make a list of the votes cast by the electors of the several states. The tellers on the part of the two houses will please take their places. So the tellers are the people who, run around and do everything. They're probably younger people who are interns or something. I don't know. Maybe some rich donor's kid. So you'll see as they go through. Mr. Johnson, President, the certificate of the electoral vote for the state of Louisiana is regular in form and authentic and appears that the votes are for GWB, for 9 votes for President and 9 votes for Dick Cheney of the state of Wyoming, received 9 votes for Vice President. And they go on and on and on. Okay, and this is how it goes. Pretty standard stuff, and what an honor it is to say that, listen, these are the electoral votes from my place, and here we are. Now, moving right along in what was an ordinary day, Mr. Ney, Mr. President. Wait. Yeah, okay. Mr. President, the certificates of the electoral vote of the well-known and great state of Ohio seems to be regular in form and authentic, and it appears therefrom that George W. Bush of the state of Texas received 20 votes for president, and Dick Cheney from the state of Wyoming received 20 votes for vice president. The vice president. For what purpose does the gentlewoman from Ohio rise? Mrs. Jones of Ohio. Mr. President, I seek to object to the electoral votes of the state of Ohio on the ground that they were not, under all the known circumstances, regularly given, and I have a signed objection. Here's that language again. Regularly given. Mr. President, has the senator... has the senator signed the objection? Mrs. Jones of Ohio. Mr. President, the senator has signed the objection. Any objection presented in writing and signed by both a representative and a senator complies with the law. Chapter 1 of Title 3 of the United States Code. The clerk will report the objection. The clerk reads the objection as follows. We, a member of the House of Representatives and a United States Senator, object to the counting of the electoral votes of the state of Ohio on the ground that they were not, under all of the known circumstances, regularly given. Stephanie Tubbs Jones, Representative, State of Ohio. Senator Barbara Boxer, the State of California. Are there any further objections? None. Vice President, this would be Vice President Pence. The two houses will withdraw from joint session. Each house will deliberate separately on the pending objection and report its decision back to the joint session. The Senate will now retire to its chamber. The Speaker of the House. Pursuant to Senate Concurrent Resolution 1 and Section 17 of Title 3 of the United States Code, when two houses withdraw from the joint session to count the electoral vote for separate consideration of objection, a representative may speak to the objection for 5 minutes and not more than once. Debate shall not exceed 2 hours, after which the chair will put the question, shall the objection be agreed to? Then we have colloquy. Now, let me just give you some basic background of the form of the objection that was made in Ohio. And the problem here was that votes. Now, let me preface. John Kerry had conceded the election prior to January 6th. All people who knew of the objection knew that this was not going to overturn the election. But nevertheless, the congresswoman and the senator felt it extraordinarily important to bring to light bad things that were happening in Ohio surrounding the vote, particularly of minority constituents and perhaps others. Mrs. Jones of Ohio. And I think what ended up happening was tens of thousands of people who showed up to vote weren't able to. They stood out for hours. There weren't enough voting machines. Stephanie Tubbs Jones and Barbara Boxer, a senator from California, have objected to the counting of the electoral votes of the state of Ohio on the ground that they were not, under all the known circumstances, regularly given. I thank God have a senator joining in this objection, and I appreciate Senator Boxer's willingness to listen to the plight of hundreds and even thousands of Ohio voters that, for a variety of reasons, were denied the right to vote. I raise the objection because I'm convinced that we as a body must conduct a formal and legitimate debate about election irregularities. I raise the objection to debate the process, and I protect the integrity of the true will of the people. There are serious allegations in 2 lawsuits pending in Ohio. Now, interestingly, there's much more than 2 lawsuits still pending in the various states in the 2020 election, and many of which are on the Supreme Court's docket. Similarly, in this case as well. These lawsuits debate the constitutionality of the denial of provisional ballots to voters. These legitimate questions brought forward by the lawsuits, which go to the core of our voting and democratic process, should be resolved before Ohio's electoral votes are certified. Again, they could have not certified the Ohio votes, but Kerry had already conceded the election, number one, and number two, I don't know what the vote count was in the Electoral College and whether the denial of the not counting of these votes from Ohio would have made a difference in that. There were more people prepared to exercise their votes, but on election day, hundreds and thousands went to the voting polls and were denied the opportunity to vote. In my own county, where citizen volunteers put forth a big effort to register, educate, and mobilize and protect the votes, there were long lines of 4 to 5 hour waits. One entire polling place in Cuyahoga County had to shut down at 9:25 a.m. on election day because there were no working machines. On provisional balloting, that county had overall provisional ballots rejected at a rate of 32%. Rejection rates for provisional ballots in African American precincts and wards in Cleveland averaged 37% and some as high as 51%. So I think it's a big problem when people show up to vote, they're not allowed to, and then you give them ballots to vote with provisionally, and then those 30% of them get tossed. Similarly, here we had people arguing against the motion to or the argument to reject the electors, saying that the spread of victory between Kerry and Bush was 120,000 votes. So, in essence, the number of votes or margin of victory by the votes in Ohio was almost an insurmountable and comfortable lead. And even if these votes from Ohio were cast in favor of Kerry, they still would not have impacted the outcome. That's a big distinction from what's going on here in the Trump-Biden election. You have razor-thin margins of substantially less than 120,000. But he even states here that the Democratic state chairman in our state has not challenged the count or the outcome in that county either. You're going to have a lot of differences here as well, because I think you're going to see a lot of representatives from the state legislatures who've already spoke come out and say that there was a problem here. And I think you're going to continue to see that. Congressman Nadler's comments. Mr. Speaker, the right to vote has been stolen from qualified voters, stolen through corruption, through political cynicism, through incompetence, through technical malfunction. Despite the fact that the widespread and documented irregularities in the Ohio election have not been proven to change the outcome of its presidential election, the loss of the right to vote by so many is unacceptable. Elections must not only be fair and honest, they must be seen to be fair and honest in order to maintain the legitimacy of our democratic institutions. This year we have dodged a bullet. If the apparent margin of victory in Ohio were closer, the Florida 2000 fiasco would look like a picnic. Elections must not only be fair and honest, they must be seen to be fair and honest in order to maintain the legitimacy of our democratic institutions. The disgraceful events in Ohio may not have changed the outcome of the election, but a closer vote could have made this belief impossible. If the apparent margin of victory in Ohio were 30,000 or 40,000 instead of 118,000, we would now be embroiled in a dispute that would make Florida look like a picnic. What is at stake is our democracy. This is not about conspiracies or phantoms. It's about the failure to count valid votes for invalid reasons. January 6th promises to be an extraordinary day. How it will play out is really anyone's guess and largely out of the hands of the electorate. However, we do know that there is a framework set forth and provided for by our founding fathers, as well as the amendments to our Constitution. We do know that there will be many objections raised. I'm fairly confident, and I don't want to inject my own politics or ideology in this presentation at all, but I'm not 100% certain that we will have an outcome on January 6th. And if we have what is a constitutional crisis, I believe that we will find our way through. There's enough history and men and women of principle and reason that we will get past whatever is going to lie before us. There's not a lot of cases in the courts that have interpreted and put to work the constitutional provisions that we discussed here today. And that gives some concern. The black letter of the Constitution says what it says. As Justice Ginsburg pointed out, there is a roadmap clearly provided for us to follow. The Constitution must be followed. As with many written documents in our Constitution, where there are holes or gaps or varying interpretations of how the statute is to be interpreted and carried out in real life terms, it is the obligation and duty of the courts to make those determinations. Before Inauguration Day, I'm quite confident that the Supreme Court will have additional opportunity and be called upon again to play its vital role as an arbiter, as the caller of balls and strikes, and as the ultimate interpreter of how the Constitution is to be read and followed in real time.